So thanks for your kind words. I'm delighted to be here today. I'm afraid my presentation may be a little bit cryptic for people who are not lawyers. I'm myself a political scientist, but the European asylum system is a very technical issue. But in my opinion, it's essential to know what's happening at the European level for several reasons. First, because as we were just discussing, the debates around immigration and asylum are very anchored into the national sphere, but at the same time, they're influenced by phenomena that are so much broader. And especially in legislation, what you see happening in Germany, for instance, at the moment, or in many other countries where reforms are being debated, it is debated as if it was a completely isolated issue, but it's not. Because especially in the asylum context, you have a series of rules that have been adopted and reformed recently at the European level by our heads of states, our ministers, and by our representatives in the European Parliament. And these are actually being also implemented into national law when there is a reform. So it's not only about a national debate, it's about integrating everything that also has been agreed on a higher level outside maybe the tie sphere of electoral politics. What I'm going to do in this presentation is basically to give you some information to better understand or have more tools in a debate about asylum. And I will first do that by giving you a few elements on how asylum relates to other kinds of migration, then give you a couple of figures that you definitely should know when you're talking about that issue, and then turn to look a little bit into, get your handed, look into the history of the system, how it developed, and what it's composed of. My research specifically at the Graduate School Human Rights Under Pressure is about the relationship or the challenges of combining in asylum policy different objectives and different priorities. On the one side, the human rights of asylum applicants and refugees, and on the other hand, budgetary and security considerations of state. And these tensions is always present. I don't think we will have time to go very deep into the stage of my research, because I think what's most important is really having the tools to actually debate about this issue. So, there are various types of migration, as you're all aware. When somebody arrives in one of our countries in Europe, it can be through several mechanisms. One is family reunification. It's actually one of the most important in terms of volumes. The second is economic migration, be it legal or illegal, temporary or permanent. And the third is humanitarian migration or forced migration, depending on the terminology one prefers. I would like to highlight that generally talking about migration, there are different kinds of forced migration, humanitarian migration. One of the groups is the internally displaced, and it's actually the biggest one. We talk about 51 million refugees in the world today. 2/3 of these are internally displaced persons. For instance, we have today the situation in Ukraine. People who have to flee the conflict regions usually go somewhere else in their own countries. But then you also have people who move across borders, and these would be asylum seekers and refugees. We'll clarify exactly who is who. And then you also have new categories of forced migrants, which are not very well codified as yet. For instance, environmental refugees, but I won't enter in that category too much. So this is what we are talking about today. So just to clarify a couple of things, because some people don't necessarily know what's what in this area. An asylum seeker, or Asylbewerber in German, is a person who has posed a claim for asylum, has asked for international protection. When this claim is recognized, that person becomes a recognized refugee. So, Flüchtlinge in German. These are two different things, and this goes with a different set of rights. So it's important to make this distinction. What's difficult sometimes when you talk about asylum is that asylum seekers may take similar routes to illegal migrants or use the same illegal smuggling possibilities. So sometimes it's hard to make the difference, and it is, of course, also for law and order officials. Many applications within the asylum system actually come from people who don't necessarily fall within the category of people who could be recognized as refugees, and they are actually maybe economic migrants. But then, of course, you go back to the question of who is actually deserving of international protection. Somebody coming from a region where the economic situation is so terrible that they have to seek a better life somewhere else could also be considered as somebody in need of protection. But it's a very narrow legal system, and that's also not very flexible. And finally, another source of confusion is that there are several types of protection. So not only asylum, but also subsidiary protections or temporary protections that are afforded in all EU states. So we'll touch upon that as well. Some figures that you need to know. So as I was saying, the internationally displaced persons is actually the largest group. The latest numbers from the International Internal Displacement Monitoring Center counts 33.3 million people, and the refugees flows are only 1/3 of this. So just to see the relationship. The refugees themselves. So we counted 16.7 million at the end of 2013. It has definitely gone up in 2014. The newest figures from the UNHCR will be published in June, so we will see what exactly that is. There are two different types of refugees. The largest type is the general refugee, falls under the general refugee definition of the Geneva Convention. There is also a 5 million population who is not entitled to the same kind of protection, and they fall under the authority of the UNRWA, which is specifically dealing with the case of Middle Eastern refugees, Palestinians. And that institution precedes the Geneva Convention, and hence people who could be afforded the protection of the UNRWA are not eligible for refugee protection otherwise. 53% of all worldwide refugees come from the countries that you can see on this graph. So Afghanistan, Syria, and Somalia. It is possible that for 2014, the relationship between Syria and Afghanistan will have changed, but as I said, the figures will be coming up. One thing that I always stress is that 86% of all the world's refugees are hosted in developing countries. They're not all coming here. The main reception countries are Pakistan, Iran, Lebanon, Jordan, Turkey, Kenya, Chad, Ethiopia. So that's a completely false perception that right-wing parties like to spread, that all the refugees are coming to the doors of Europe. It is completely untrue. Only 2.5% of the world's refugees were hosted by the European Union in 2013. So yeah, just keep that in mind when you talk to Pegida people, for instance. Asylum seekers. So like I said, asylum seekers are people who are looking for protection. They're not recognized as refugees yet. There were 1.2 million worldwide. It's not a huge number either. Sometimes perceptions get a little bit twisted, right? That's the figure from 2013. That's a 15% increase compared to 2012. And for industrialist countries, it's true, the number of applications is in rise compared to 2012 of 28%. So it's a bit more than the general percentage in the world. 19% of all asylum claims in the world come directly to the UNHCR, and all the others, so 80%, go to national authorities. Since we're in Germany, I was just citing the figures, but I see that there are not so many Germans in the room. So Germany is the largest, received the largest number of applications in the world. Since 2013. 2014, it is estimated that Germany received 126,000 applications. So of course it's a large number, but it's not a huge number either. And maybe surprisingly, those applicants come mostly from Serbia, Russia, and Syria, the former Yugoslav Republic of Macedonia, and Afghanistan. So, what is the right to asylum? Now that we've talked about these different categories and the reality of the numbers. Just to give you a bit of background, Remember, at the end of the Second World War, there are 50 million refugees in the world, and in the framework of establishing a whole range of international law instruments defending the rights of human beings generally, asylum was considered as one of the key rights to secure. So in the International Declaration of Human Rights, Article 14, ingrained the right to seek and enjoy protection in other countries. A few years later, in 1951, was the Geneva Convention adopted. It provided with a definition of who is eligible for a refugee status, and that is someone who is unable or unwilling to return to their country of origin, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion. So this definition is extremely important. Actually, basically every word in this definition has been the object of endless discussions in the academia and so many judgments as well over the last 60 years. The second thing that the convention does is establishing key principles. Non-discrimination would be the first. So that means that anybody should be eligible for asylum, regardless of their social group. Non-penalization, that means you should not be penalized for entering a country illegally while seeking protection. And non-refoulement, which means that you cannot send a victim back to their persecutors. So now you see in our politics today, these three principles is something we should really keep in mind because they are actually very often endangered by the discourse of people who want to restrict access to asylum, to international protection generally. And non-refoulement is a very key principle, especially when on the debate of Fortress Europe, Frontex, and so on and so forth. And then finally, what the convention does is setting minimum standards for the treatment of refugees. Now, all EU member states are parties to the convention, and in theory, they're supposed to implement these rules themselves in their national law. But then the convention is also very broadly defined and formulated as most international law instruments. So there was a lot of discrepancy between member states, and especially after the war in ex-Yugoslavia, like you were mentioning before in Germany, the change in the asylum law, many countries were engaged in a race to the bottom, trying to make their asylum system as repellent to refugees as possible. And my question, looking at the European system, which has developed since the 80s, is actually, did it serve that development? Did it allow European countries to restrict even more access to their asylum, to their territories and to their social welfare states? Or is the story maybe a little bit more complicated? So let's look a little bit at history. So why would there be European integration? Oh, there is no battery, apparently. No worries. So, since asylum and migration touch upon really like the control of your nationality, of your population, your territory, why would the European member states actually decide to cooperate in this and to commit to an EU legislation? If you remember, I don't know if many of you are familiar with the history of the European Union and European integration, but I'm sure all of you have heard the term Schengen. And right, so basically we have a single area, a single market, and a free movement within that area. And that creates the necessity to have a cooperation in controlling that territory. And basically what happened is that one of the first issues on the agenda while thinking about how to manage this common area was how to coordinate the management of asylum flows between the member states. Because what many member states wanted to avoid was that somebody could apply for asylum everywhere. Once it would fail in one country, it would go to the next country, try it again, and so on and so forth. So there was some degree of harmonization of asylum policies and the development of some burden-sharing mechanisms. So just a little timeline so you can see all these things that happen. We're going to go like one by one. So first phase was very loose intergovernmental cooperation between ministries of law and order. So they came up with the Schengen Convention in '85 and then the Dublin Convention in '90, which is a treaty that was signed outside the European institutions and that allows all the EU member states to coordinate and exchange information to make sure that there is only one country responsible for one applicant. So that was what we arrived at in the 90s. Then, in '92, the Maastricht Treaty created, the European Community became the European Union, and there, immigration and asylum became a policy within the European Union, whereas before it was completely outside. But they kept intergovernmental decision-making structures. That means even though it was within the EU, it was still a matter decided solely upon by the ministry officials in the Council of the European Union. Several resolutions were adopted, including some on safe third countries, on safe country of origin, and asylum procedures. Then in '97, another treaty, the Amsterdam Treaty, asylum and immigration become a community policy. What does that mean? You have change in the decision-making structures that make them more inclusive for the European Parliament, and you actually have an objective to create legislation on minimum standards for reception, procedures, qualification, temporary protection, and burden sharing. Because the member states were reluctant to actually have the Parliament and the Commission meddle too much in that area, there was a 5-year transitional regime. So for these years, there was limited power for the Commission and the Parliament. And it's under that regime that we had the adoption of the first legislative package between 1999 and 2005. During which the entire system was set up. We'll look in a moment at what it's composed of. And coming to the present time, so since 2005, you have in that area the completely normalized decision-making system, so the new rules that were adopted afterwards were adopted as any normal legislation at the EU level, with the Parliament and the Council being both involved, and with full jurisdiction from the European Court of Justice. So that's a very important development after the Lisbon Treaty in 2009. That means that if European states do not comply with European legislation, then they will get into trouble at the court. They can be actually pursued for that. And another important development with the Lisbon Treaty was that the Charter of Fundamental Rights became binding. So, and in the Charter, you have several important things, such as, again, the right to asylum in Article 18, the principle of non-refoulement we talked about in Article 19, and principles of fair trial and legal remedy in Article 47. So under that new setting, you had a whole range of reforms for all the instruments that had been adopted in the previous phase in the transitional period. So that's how the CES developed. Now, what is it made of? So I'm really sorry if that's too technical. Do cry if if you need some explanations. I don't know if you're familiar with EU legislation, generally speaking. Basically, we have treaties that establish principles, and then you have legislation that implement the principles. So we're not going to go through all that in detail. Just to let you know, in the Treaty on the Functioning of the European Union, you have first a general provision saying, oh yeah, awesome, we're going to have a common policy on asylum, migration, and external border control. And then you have an article, especially on asylum, that sets out all the different objectives that must be realized. And it's on that basis that legislation is then adopted. So what are we talking about there? We have two types of international protection at the EU level that are regulated. It's inspired from national legislation, but basically it really puts in law, black and white, what an asylum seeker, a refugee is entitled to and who is who. So first you have what we call the qualification directive, so that establishes international protection. A big innovation is that it regards not only refugees, but also beneficiaries of subsidiary protection. And it establishes the eligibility criteria, therefore, and the content of the protection that it regards. So residence permits, travel documents, access to employment, education, and so on and so forth. And then you have temporary protection. That's 1 to 3 years. It's another directive, and it's designed to cope with emergency situations where you have like a war just outside of Europe and thousands of people come, which is pretty much what is happening with Syria at the moment. And there again, there is a setting of minimum standards across the board, and also a resettlement mechanism that's not very well developed so far, but it's supposed to be enabling the spread of migrants across EU countries. Then another very important pillar of the CEAS is how do you allocate and control asylum seekers? This is a problematic system, but it's actually quite essential. It's about, so first, the Dublin Treaty that became a regulation and that was reformed twice. The principle is that there will be only one application in the EU and that the country where the person first arrived is responsible. So of course, people don't arrive in Europe only in boats and smuggled. Lots of people arrive on a tourist visa or on a student visa, stay on, and then claim asylum. Yeah, still there is a very high burden on the border states of the European Union, and this is addressed by the possibility to do family reunification, or if you've been previously living in another country of the European Union, you may be allowed to apply for asylum there, but it's difficult. And the Dublin system also provides for procedural requirements for transfer between member states, especially the right to an interview and the right to appeal. There was a series of recent judgments at the Court of Human Rights and the Court of Justice that forbid transfers if an applicant will be exposed to serious harm. So that has meant that several transfers, for instance, from Belgium to Greece, were halted in recent times because the situation in Greece is too complicated for asylum. Then the second part is controlling and making sure that people are really staying in their country of where they have been allocated. And basically, when you apply for asylum, your fingerprints are registered in an EU-wide database. And so basically, it's available for any country. So the first thing they check when you register a claim is, have you ever been registered anywhere else? And this data from July 2015 will be available for terrorist investigations, which is a big issue for human rights activists. And then, during the assessment of the asylum claim, what will happen to you? So there is a directive that is concerned with reception conditions for applicants, and that regulates really quite in detail what you're entitled to and what the states must provide for you in terms of housing, the provision of food, and the access to employment, as well as the access to medical and psychological care. So you see, this is all rather detailed, and you can, well, of course, all of these provisions are still quite quite broadly defined, but still it gives some limits that the states must respect. And then the second aspect is the procedure that you have to follow. So there are a series of principles that guarantee the rights of applicants, and also the goal to harmonize proceedings and to have one procedure for the entire union. Then you have the return directive when people have failed their claim and are being sent back, and also attempts at cooperating with external countries to either ease return, prevent the influx, or resettle refugees. Then you also have some agencies and funds, but I'll just skip that. And yeah, just turning for a couple minutes to my project. So basically, there is a lot of political science research so far that has shown that urbanization has been an avenue for rather prioritizing the interests of states, also thanks to the procedural setting that allowed this. But as we can see from the different reforms that have been carried out now in the more democratized setting, actually there is a real evolution in the law, and constraints are very strong on member states to respect at least minimal standards. So my approach is basically to look at the implementation of EU law in the different member states and to make a comparative study looking at whether the conclusion of the previous research are still accurate. But I'm still quite early in my studies.